Calling 2024 CR 010117, State versus Eric Kelly. Can I have parties approach and announce for the record for the state? For the defense?
Robert Bears on behalf of the office of Kelly Green.
All right, and are you Mr. Kelly?
Yes, ma'am.
All right, do you have any objections to Attorney Barron standing in for Attorney Kelly?
No, ma'am.
Right. And I'll note for the record.
And pause right there, because this is where the justice system shows its colder side. Even with a serious medical history like lymphoma, the charges don't soften. In Texas, an aggravated assault with a deadly weapon is no joke. The judge must balance empathy with the law, and spoiler, the law usually wins.
Record that the court is in receipt of the discovery acknowledgement. Counsel, have you received all of the discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Let me see here. I'm trying to find the, here we are. Mr. Kelly, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Hey, Judge.
State, are you proceeding on the indictment as presented? Did you review the court admonishments with your attorneys? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right. And count two, the charge is aggravated assault with a deadly weapon. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
That's correct.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Correct.
That's yes or no?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
To assist in his defense, I believe he's confident to enter his plea.
Do you believe he was sane at the time of the offense?
I do.
Mr. Kelly, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
That's correct.
Court will find, yes or no?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count two. They're asking that your punishment be assessed at 2 years in the prison. Do you understand that if I find a deadly weapon was used, there will be an affirmative finding of deadly weapon?
Yes, ma'am.
And there are no applications. This is to run concurrent with County Court Cause number 708-473, 709-900. State will take in consideration 2024 CR 0497 and 2024 CR 5344. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Judge, there have not.
Then to the offense in count two, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers states exhibit number 1 and attachments.
There's no objection.
Did you review the waiver and stipulations with your attorneys? Did you understand it and sign it in all the appropriate places?
Correct. Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, so does anyone want to explain why the court should go forward with this agreement?
Judge, I'm not familiar with the facts of this case.
Okay, sure.
Judge Jason Garaham for the state,
Yes.
and Judge, in this particular
Okay, this is the moment where we usually expect the defense to deliver a heartfelt pitch or the state to drop a bombshell. Instead, both sides stumble like someone just handed them the script 2 minutes ago. Notice how neither attorney seems fully briefed. This happens more often in busy criminal courts than you'd think. But it raises a big question. How confident can a defendant feel when the lawyers sound unsure?
case, I'm sorry, I just came in right now from out of court.
Mhm.
My question, I think your question was of why you should proceed with this,
Yes.
is that we've talked to the victim in this case, and we feel that this is the appropriate outcome in this case.
All right. So you've spoken with the complainant and they're aware of this outcome and they're in agreement with this outcome?
Yes.
All right, thank you.
Judge, just so you know as well, Mr. Kelly has been suffering from a lymphoma since he was a child, about 10. He's had a couple occurrences of it, and apparently it's rearing its head again. He has a lymph node in his eye that is significantly swollen or tumor-like, and probably going to need attention on that while he's in custody.
All right, court is finding you guilty. Court will sentence you to 2 years in the prison. Give you credit for any time served. There's an affirmative finding of deadly weapon. This is run concurrent with County Court Cause number 708-473, 709-900. Take in consideration 2024 CR 0497 and 2024 CR 5344. And there is to be no contact with the following. The first is the street location of Gateshead Road, Gateshead Road. That's San Antonio, Texas, 78251. And there's to be no contact with the following persons. Ryan Dekrone, Dekrone. Tamara Scrum. Marissa Magana, Magana. Anything?
Marissa Magana, she's not a complainant in this case. That's Mr. Kelly's girlfriend, fiance.
She's the co-defendant. Are you all married?
Yes, ma'am.
When were you all married?
We haven't finished the paperwork, but she's got issues.
As far as I know, and I've checked the record just this morning, she was never a co-defendant in this case.
No, they have her,
Defending a fraudulent use or possession of ID case.
no, they have her listed as defendant number 2 in the,
They never
paperwork.
charged her.
That's correct, Your Honor. I don't think she was ever indicted under this case. I mean, it is listed as a suspect. I mean, not a suspect, like, as a co-defendant.
they said that suspect 2, which is her, was also found to be armed.
I don't think they even ever charged her with it. They did charge her with fraudulent use or possession of IDs.
All right, while they look for that, there's to be also no contact with Desiree Johnson. Itzel Lugo. Prudencio Benavides. Raymond Rangel. Norma Villarreal. Yes.
Okay, okay.
Yes.
Sorry, Judge, that case was sent over as a ag robbery, but it was rejected for further investigation. That's the extent of it. Usually further investigation means possibly insufficient evidence on her. But as far as I know, it's been rejected at a intake level by the DA's office.
All right. Then I'll remove that as a part of the sentence. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition.
That line right there, there's always room at the prison, is the justice system in one sentence. Harsh, matter of fact, and completely true. Judges say it to snap defendants into reality. It's part warning, part wake-up call, especially when someone's battling health issues on top of criminal charges. The message? Your choices will fill a prison bed long before compassion ever empties one.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, so we're off the record. You have all these health conditions. You need to start making better decisions with your life. You understand? As I'm going to tell you what I tell everybody else. We could not have funding for water or whatever it may be. They will always, and when I say they, the government will always find room to fit people at the Bexar County Jail and to fit people at the prison. There's always room at the prison.
For the cancer treatment as well.
What I'll do is I'll put on their therapeutic community, but you need to let them know that you have medical issues. They usually will have a medical clearance for you before you go. And so they'll see if there's some issues.